As for me, I have a lot to say about what is on documents that have been released. The thinness of a search warrant's probable cause statement, very strange. But it's not for me to fight these things on YouTube. And anybody who suggests that I should, or that I have some duty to explain to you my legal strategy, my legal avenues for doing this, or that anything I say or don't say is somehow either an admission or an omission of some duty I owe to the general public. Anyone who's saying that, anyone who is saying that is a lying grifter in the truest, not funny sense of the word. And I have zero respect for anyone like that, especially if they call themselves a lawyer. It was going to be a more entertainment-focused show. I know people are going to have commentary. They're going to have questions. They're going to have demands about my situation. And I'll just have to say, all the things I'm going to say impactful to my case will be said through counsel in court. They won't be said here. I'm sitting here and I'm going, I know they keep saying that I'm a non-practicing lawyer, proudly fucking so. I know they keep saying it, but I'm just sitting here going, but their analysis is bad. And it's great because they're going through all these analyses, right? They're like, no. Look, the video's the exact same. Of course it's the exact same. Look, it's there's no edits here. There's nothing here. There's nothing here. It's like, but what you're doing is you're arguing about the sufficiency of the evidence for a trier of fact. But we're not at trial, guys. We're not even close.
No, we're not making arguments about the sufficiency of the evidence, Nick. We're not even close yet. Once again, I know he likes to think he's practicing, but as a wise man once told me, he's working without tools. There's a long way to go, Nick. You're claiming that this wasn't a reliable thing to use. And we're pointing out it's reliable.
Mm-hmm.
Like, Nick's going to say it's not reliable. You can't trust it. Well, but Nick's going to say somehow that's different. Let's listen to Nick.
Applicant therefore knew the video presented by Imholte in his video blog is an altered rendition of the video that cannot be authenticated. Applicant failed to inform the judicial officer of the unknown provenance and unreliable nature of the clip. Yeah, no. No, I appreciate your enthusiasm and all, but no. The thing speaks for itself a little bit on that one. So, okay. So we included a minute 10 of this video as part of the evidentiary picture, but it is the moment of criticality relating to the thing. So no, I don't think so, but okay, fine. Applicant misrepresented they've been able to review the video as taken off Nicholas YouTube's and Rumble media sites. Applicants say the video was taken off the social media sites. This was a misrepresentation as they are placed in private status. Wow. Talk about trying to slice it really thin. That's good. Oh, it wasn't taken off, Your Honor. It was merely set to private status. Yeah. Okay. A distinction without a difference, my friend. The distinction without a difference. They don't care.
Rekieta is using a combination of an appeal to authority, fan loyalty, and his audience's political bias to gaslight them into thinking that a warrant requires a very high standard, when it really isn't.
I spent basically an entire live stream saying we really only ask cops to not lie. This dork says I'm trying to convince people that is a very high standard. This is typical. People place me into their argument fantasies and pretend I make claims I don't. All we ask of officers requesting a warrant is please just don't lie. Nick, a very high standard, pick one.
I never said they shouldn't challenge lies, but this is definitely not the case of a cop lying. So thanks for the straw man. You also didn't rebut anything I said about harmless error or that PC is a relatively low standard, by the way.
I watched his video. Cop, the video was taken off of his YouTube and Rumble channels. Cop, here's the video provided is not from my channel. Cop, this is not a case of the cop lying. An idiot.
Typical Lolbert, conflating the standard of evidence for a conviction with that of a probable cause. Yeah, I broke the law, but the only way I got caught is because the cops violated my rights. They didn't witness me do drugs. A trained observer merely saw my behavior and made a guess, as a trained expert, that I was on drugs with powder on my nose. There was no way they could have known it was coke.
That's not even the argument.
Being the OG vid isn't everything either. I can say that even watching the OG vid on the OG channel can have a material difference too. For example, if I watch the same video from the same channel, but on 360p instead of 720p, it could cause a difference in what I'm perceiving.
What resolution was it downloaded and re-uploaded in and viewed by the officer?
Oh my god, why do you keep coming back? You don't need to defend yourself against every little thing. How insecure about yourself do you have to be to do this?
This isn't an answer.
Do you just want them to call Cog a retard? Will that give you satisfaction, Baldo man?
It being Cog is irrelevant, I didn't even know.
Those would be relevant points to bring up, no? But I didn't see that anywhere in your motion to suppress.
Answer the question.
I don't know what resolution he would have watched it in, though it's reasonable to assume that just left it at default or tried making it the best possible. The resolution in Cog's video says 720p by default, but the same questions can be brought even if the cop watched your
Wrong answer. It's the wrong answer because we're not moving to suppress the video, and it isn't about the accuracy of the video as it stands today. It's about the cop using a copy of a video that he hasn't verified against the original and not just telling the judge that. Instead, he chose to lie. The lie was used to justify an intrusion into my Fourth Amendment rights in violation of the Constitution. You're trying to argue the veracity of the video as evidence. I'm saying the officer just had a duty to inform the judge of a tiny amount of doubt and chose to lie instead. This isn't an issue at trial because authenticity of the video would be obviated by just getting the original from YouTube. The video's admissibility would stand or fall on any number of grounds. You're arguing the wrong point because you misunderstand the issue. The cop didn't watch the 4-hour stream and the 4-hour copy and verify them. All they had to do was provide the judicial officer with information that it wasn't the original, but again, chose to lie knowingly.
You're moving to suppress what the cops found by calling into question his credibility based on his description of the video. But I don't see how it's a lie. At worst, he wasn't precise enough. Even uncivil law thought it was a distinction without difference. I obviously can't.
No, I'm not! Look, the cop says it's the original to the judge, but he knowingly watches a copy. The reason he doesn't just tell the judge it's an accurate copy is because he can't do so truthfully. He has two options: lie or tell the judge it's a copy and that it's possibly not accurate.
Cite Sean, because you'll just say he's biased. But I would think that uncivil law wasn't biased against you. Or maybe I missed the relationship change between you two. Perhaps you addressed it, but I'm not gonna scour your stream to find you talking about uncivil law somewhere.
Sean and uncivil are both retarded on this issue. The lie guarantees the warrant. The truth might give the judge pause in allowing cops to burst into a home. That's what matters.
If I said that I found a video that got removed by the original uploader, am I lying if I don't explicitly say that it's a re-upload? Wouldn't the mention that it got removed pretty much imply that it's obviously not the original video from the original source?
Pretty much imply cops kick your door down and take you to jail.
He never said it was the original though. I looked at the warrant, and he just said that he was able to review the video that was taken off of your YouTube and Rumble. Any reasonable person would think that he could be referring to a re-upload. At worst, imprecise, not a lie.
But he wasn't able to review the video that was taken off of YouTube and Rumble. 1, it wasn't taken off, it was private. 2, taken off could also mean taken from. But it wasn't. He wasn't aware of the video before it was made private. Either meaning leaves the impression that he got the video that was taken from or taken down from YouTube or Rumble. But he didn't. He got a copy, which he did not make and could not possibly verify as accurate. This is according to his own words. If the answer implies it's the original, I get to kick your door down and take you to jail. If the answer is that it's a re-upload, I don't. Yeah, it matters.
They never said anything about it being unedited. They didn't say where the source came from. They just said that they were able to review the video after it was taken off of Rumble and YouTube.
That's not what he wrote, and that's the best part. You're assuming and inferring his meaning, and you're defaulting to deference. Broken man. When you're arguing over just how untruthful the sworn affidavit should be allowed to be so the cops can kick your door down and arrest you. How's the leather?
I don't know. This is pretty convincing. This is very far from a lie or misrepresentation.
Do you realize that the officer lied in all of the possible meanings? The amazing thing is, in every single instance provided, the officer's statement is a lie. Dude, he knew he was not watching my video. He told the judge he was watching my video. The mere act of downloading and re-uploading the video changes the file due to compression. We don't even need to argue how much it changes, but it also could have several other edits, color grading, added effects, etc. All of that could happen. He knowingly did not verify that it didn't happen and instead told the judge he watched mine. Any of those edits and even the normal compression issues of a re-upload raise the possibility that what he thinks he saw isn't accurate. His duty is to inform the judge of the possibility that what he watched isn't an accurate representation. Instead, he lied. Do you even realize that it is almost a guarantee that he still has not seen the video from YouTube and Rumble?
Also, if he was intentionally trying to lie, why would he even mention that it was taken off the day before? Wouldn't he think omit that information too? Because a judge might ask, wait, how did you watch a video that was taken off the day before?
No, because he said he reviewed the video, not my video. He wrote it in a way that represents it as the video, but it isn't. Again, the mere act of download and re-upload means the files are actually discernibly different. Again, do you realize that he, right now, almost assuredly cannot truthfully state that he has compared the two videos and found them to be accurate?
He told the judge he was watching my video. You literally said that he told the judge that he was watching your video by using the word my.
So my video versus the video matters, yes?
No, I don't think it does, as far as the affidavit goes. But I am pointing out that you tried to gaslight me into thinking that me saying that he said watched your video was incorrect, even though you yourself had said that he told the judge it was your video.
They both matter, they're both lies.
Even if that were the case, you failed to argue how those misrepresentations, not lies, and you have even asserted on your omnibus stream they could be unintentional omissions, how correcting those misrepresentations could have changed the judge's decision. In fact, your lawyer's arguments were very passive and nebulous. You got ripped off by Randazza, and now Barnes is ripping you off via proxy because you can't afford him.
No, you're arguing something completely different. You don't know what stage of the legal proceeding you're at.
No, because he said he reviewed the video, not my video. Nick, he told the judge he was watching my video. Nick, pick one.
Easy, I pick both. Each of them is not true. He didn't watch my video and he didn't watch the video, he watched Cog's video, but you realize I posted what he actually wrote, so it doesn't matter what I pick.
So, what if he was able to review a copy that another officer pulled from your channel during the 12 hours before you privated it? But he, as the substance abuse evaluator, wouldn't get to watch it until he came in the next morning. Because they totally weren't onto for days or weeks when the mandatory reporter came in. This is why your argument is very weak.
I suppose we need a hearing to ask him then.
And exactly how much will you maul when your motion fails? And will you plea out like a bitch-made, non-practicing white bread ass?
Objection, non-responsive.
The problem with your argument is that it's a desperate attempt to grasp at non-existent straws to try and cover up the blatant truth that you left to do coke. Your arguments that artifacting from a re-upload made white powder appear on your nose is hilarious and sad.
I didn't make that argument. I'm saying that argument isn't even a part of the issue. Everyone is arguing the wrong thing.
The cop doesn't have to base his investigation or warrant off of the CPS result. He's doing his own separate thing. He also never called Aaron a concerned citizen. He even said they had a falling out. Yeah, Rekieta argues that he downplayed the bad blood by merely saying,
This shows just how much you don't know about the legal issue, and it's maddening because you won't listen to me, and no one else will bother explaining it.
But it's not a lie to say that it was your video. It was the video you produced. Or that it came from your channel. It came from your channel by way of another channel. There's an omission there, but it's not material with respect to probable cause.
The cop didn't say I produced the video or that it came from my channel. He said he reviewed the video that was taken off. The video wasn't taken off. It wasn't the video. The video wasn't taken down. And the video was actually from 520. Literally every part of this is untrue.
You're asking for all the evidence that was obtained through the warrant to be suppressed as the result of an invalid warrant. But okay.
They didn't obtain the video from a warrant. It's the one thing that wouldn't be suppressed. You're so specifically wrong that it's actually funny.
I think we all know what we personally think the outcome will be. No point repeating ourselves. Let's just wait for the outcome now.
Cog, you're a retard, so no one is asking. Of course there won't be a suppression. It is not a motion to suppress. You people are stuck on the wrong argument.
Your motion is to have the warrant thrown out while also branding the officers responsible for it on the register to not be trusted again. I love how you think I'm a retard yet. You're the one who got caught with an oz of cocaine in your house. Pretty retarded.
Cog, asking for the warrant to be thrown out because an officer lied in the affidavit is wildly different than asking for a piece of video evidence to be suppressed. Be thankful the cop watched your video. At least someone did.
They didn't sign the warrant on seeing a logo. They signed it seeing you wasted on stream with cocaine on your nose. Add this to the CPS reports that may not have been acted on by CPS, but exist as a testament to how you were as a parent. Makes sense to anyone that's not you.
They actually don't exist as a testament to how I was as a parent, because they were found to be untrue before the warrant and found to be untrue after the warrant.
The warrant used the fact there was a report. Add that to coked up Nick on stream. Regardless, they didn't go in for anything child-related. They went in looking for drugs. They found those drugs. They found those drugs in the child's hair follicles. Cope Dick.
Read the warrant. They went in for child-related things. It's the first part of the request. It was also a lie. Does it bother you at all that everything you're saying is wrong?
Color me corrected. So they went in with a warrant based on both. And you delivered with a bunch of cocaine and a child with cocaine in your kid's hair follicles.
Yes, based on both, except one had already been investigated and determined not to be sufficient for the statute, even if accepted as true. The cop lied by not mentioning that he was informed that even if true, it didn't rise to the level of a crime. You can't look for evidence of a non-crime. The cop lied because lying allowed the warrant. The truth would not.
All the things I'm going to say impactful to my case will be said through counsel in court. They won't be said here.